legal know-how. And a big shout out to Salt Lake County. Sadie Mae, Megan, thank you for having us. Thanks for letting us participate with the group here. I will say yesterday we had our cultural connection. We're VEST. We provide the EAP services with the county. And we had a session on financial well-being where we talked about really what we need to know about financial planning. So we'll share a link on that one later. If you want to take a look at that, you're welcome to. If some of you participated, thank you. And if you did participate, yes, this is the same shirt, but I did not wear it for 24 hours. I promise. I just wore it when I hopped into the studio here because of my wonderful brace that I'm wearing. It makes the brace just a little bit more comfortable for me. I did change from there to now. First off, I want to thank Justin Cutler, who's joining us today. Justin is an estate planning attorney, and you'll get to know him a little bit better. Justin, just a little bit, introduce yourself, a little bit of your background for the folks on here.
Yeah, so I started my own estate planning firm about 10 years ago out of Draper, and have been doing wills and trusts mostly. I've added a partner since that time, Justin Riley. So it's not very original, but we are Cutler Riley is the name of our firm, and estate planning was what we enjoy, and we've been to court. We don't do that anymore. Now it's just helping people get out of court and avoid all of that, and that's kind of our practice area. So and then a little bit about me. I grew up in the Sandy area. I'm good friends with Ted's son-in-law, and we got introduced, and we play golf on a regular basis. So that's how I know Ted, and that's one of my passions is golf. So
I will add, very good at golf too. So it's always intimidating going with Justin and being with Tony because they're really good golfers. I would call them golfers. I play golf. They're golfers. There's a difference there. But today we're going to be talking about trust and estates. And so I want to start with you thinking about this scenario. Your parents are getting maybe a little bit older. Your father has passed away, and you have your mother. And one day your mother passes as well. And when that happens, and let's say you've got you're an only son, or you have a couple of brothers, and there is no will. What happens? Put in the chat if you have had the experience of having to work closely with somebody who has passed and dealt with any of the estate planning issues when they go. I would love to put in the chat if any of you have had the experience, and you can put in there, yes, I had the experience, it was awful. Yes, I had the experience, it was wonderful. Just trying to get a feel for how many of you have dealt with this before, so we kind of have an idea of where to go with this. So any experiences with that? Anybody want to put something in the chat? Love to hear from you. We'll be watching that. So that scenario exists for me. My father passed away a few years ago, and my mother is, she's getting quite old and can't take as good a care of herself as she has in the past. The benefit for me is my father was an estate planning attorney. So he had everything in place, and so it's made it much, much easier. But there are still issues that come up. And so even now with my mom, she has been basically passing on and providing instructions for different things that she has in her house. When it comes to the things that we love. She was an artist, and was an artist. She doesn't do that anymore. So she has her original artwork in her house. We all have been fortunate to get some of that already, but we might have some favorite things where we're kind of, she wants everybody to lay claim to it so that we don't have that issue when she passes away, that there's any real issue or fighting or those sorts of things. So I'm going to ask the question, Justin, what does it mean? And will you explain what it means to die intestate?
That simply means someone's passed away and they don't have a will or a trust or any estate plan in place. And so basically the state decides on what happens, who gets what, whose job is it to distribute everything out, pay debts. And that's where the probate court process begins, is the court oversees all of that and determines how everything's to play out.
So you've just said that if we die intestate, the state, we're basically abdicating all control over everything that we've owned and saying, state, you decide?
Essentially, yeah, there's a Utah probate code which the state legislature has written to determine an order of priority on who gets what, and spouses and kids, and then who has a priority to be the executor of the estate. And so basically, yeah, our state government decides on how everything is to be distributed out.
As I'm thinking about that, if my mother were to die intestate, or if I was to die intestate, I think one of the last people I would want dealing with that is the government. I mean, look, I love the state and I think they do great things, but I don't know that I want them deciding who gets my kids. You're telling me they decide who gets my kids if they're minors. They decide where my assets pass to. And that's what
Exactly.
it means
Yeah,
to die intestate.
exactly. If you don't have a plan in place, the government has one for you, and you'll have to use theirs. So
I'm going to put you a little bit on the spot. Do you know roughly how many people, say in the state of Utah, what percentage would have a will versus don't have a will? How many people die intestate?
I I've read statistics where it's anywhere from 75% to just 25%. I think it's somewhere probably in the middle. About half of people that pass away don't have a will or a trust.
So we've got the state making these decisions for half of the people in our state. It just goes by code, goes by rote.
Exactly. Yeah.
Boy, that's huge. So I hope that as you think about this, that you ask yourself, all right, when do we really need a will and a trust? So I'm going to jump to this screen right here because we're going to look at this. This is why estate planning really matters. And as you look through these, it's not just for the wealthy. It's for anyone who wants a say specifically in what happens after they pass. Now, if you've read the state statute and you think, hey, it's wonderful, they do a great job of passing it out and sending it wherever, that's great. You can let the state decide. The issue there is there's a cost associated with probate
Mm-hmm.
because you have to go to probate court if you die intestate. So there's a cost to go through the state system of saying, oh, we want to default to how the state decides how everything goes. And so your estate, let's say you have $50,000, first 5 or 10,000, I'm assuming probate probably costs 10 to 15, but I don't know. It's been a while since I've been to probate.
What's wrong?
There's two kinds of probate in Utah: informal probate
Hey,
and
what's wrong?
formal probate. Informal probate's a lot less costly. It may be
Just
a
a little
few
too
thousand
small for
dollars.
both of you guys.
And that's if there's no disputes. Everyone,
Watch
the
your
whole family
toes.
agrees on everything.
Watch your toes.
Formal probate might get up to 10, 15 or more $1,000 if there's disputes and things like that. So it is costly. More so than that is there's also a time element to it. The court process is not quick. So families are having to wait on court hearings and things like that really delay everything.
Okay, so if you die intestate without a will and without trust, you're looking at time and you're looking at money. So this is why estate planning matters. It also provides that clarity for loved ones because you want to protect your family's wishes and give them that peace of mind that things are going to go where they should be going. And so Justin, say for example, my mother has a painting and one of the paintings is worth $50,000. And I'm not exaggerating. She got a painting, inherited one from her mother that ended up being kind of a famous artist. So she had a painting in her living room that was worth about $50,000. I want it. My brother wants it. There's no directive.
Mm-hmm.
Are you saying that probate is the way that ends up getting worked out if we can't agree?
Yeah, a judge might decide on we're going to have to just sell the painting and split the proceeds, or one of them may decide to buy out the other, but a judge is going to have to step in and decide who gets this, how is this going to be handled. So not the family.
All right. Well, that is, thank you for the statistics in there too, Angelina. That is good information for us to think, to be aware of and look at. So I hope, and if you have any questions about intestate or what that process is, we're going to try to answer some of those as we go through. But if you have questions as we go along, put them in the chat. If we have the opportunity, we'll grab those and respond to those. And hopefully what will happen is we'll get your answers, your questions answered as we go through this. So, but if you have anything at any time, please put it in the chat. All right. Well, some misconceptions that we want to go through. And this happens a lot. So my kids now are of the age where they really need a will and a trust. And because I've done some of this work in the past, I can help them put something basic together without too much trouble. But one of the things that comes up a lot of times is I'm too young or I don't have enough. These are things that are really important. And we've talked about the state deciding about that. What are some of the things that, in addition to these, because those are two big ones, what are some of the other myths that you hear or come across that really keep people from engaging in an estate planning process?
A very common one is that it just seems overwhelming. Getting an estate plan, you have to meet with an attorney. It seems like it might take weeks or hours meeting with an attorney. For a lot of people, it just seems overwhelming, and that's why they put it off. Which in reality, we can make it a very simple and efficient process to get your estate plan done. A lot of times, we get it done in a week or two. I hear those ones all the time. Maybe either I'm too young or people will call for their elderly parents and say, "Oh, mom or dad, they just have a house. They don't have much. Do we really need anything?" And absolutely, if you have a home, that home's going to go through probate court. Even if that's the only asset a family has, that's going to cause a lot of headaches. So, everyone's going to die one day, so everyone needs a plan for when that happens.
Well, and I think one of the things that you've just said, and what the way I started out this discussion, right, is we might not necessarily be thinking of you right now. And sometimes the better way to look at this is you have somebody in your family who might be closer, because we all believe we're going to be immortal and we're never going to pass and all that sorts of things. And that's just normal, right? And we should believe that. But there's somebody in our life that maybe we can encourage them to say, hey, like in my instance, if my mom passes, well, she doesn't have anything to worry about.
Right. Yeah.
I mean, because I'm there to clean up stuff. And in my case, it would be, I've got 3 great brothers who also help with that. And again, she's set up nicely, so I'm not overly worried about it. But if you're on this call, you might have somebody, an elderly parent or somebody, or a brother or sister, somebody you might need to think about. Now, that's a great place to start thinking about it. But you also need to look at yourself. And the trigger for me when I was a little bit younger here and was doing a little bit of this work really was, it was kids. Because if one or another of it in a couple pass, usually you kind of know some of the things that are going on, even though you might not know them all. It's still important to have these documents in place. But once you have a child, you want to specify and you want to arrange with somebody who's going to get guardianship of that child. This is a huge, huge issue that if you do nothing else, that you put something in place, because otherwise you might have parents, you might have siblings, you might have in-laws that are all making a play thinking they're going to be the best guardian for this child. And you may have already identified, you know what, my sister would be the best bet. But unless you specify that, unless you put that in formal legal documents, it's going to go, and the court is going to hear the arguments from different people saying, I should have custody. What have you had experiences with that?
Yeah. A lot of my younger clients, the reason they do come to see me is because they have younger kids. They want to have a say in who's going to raise their kids, especially if they have different viewpoints or than other family members. They want to make sure that the right people are raising their kids. And you're right, if they don't have a will in place, then ultimately a judge is going to listen to all the arguments from the family, and he or she's going to try to make their best decision on where the kids should go, but it not necessarily is going to be where the parents would want them to go.
All right, huge issue. And again, I hope one of the points, and I hope you get this out of this, is you don't have to spend a ton of money, but you've got to put some basic things into place, or you really should think about getting those into place. Now, I understand that the county has and will be having some benefits that are available that you can potentially opt into, that you can look into. So I encourage you, as the open enrollment's going to be coming up on us here probably within the next couple of months would be my guess, that you look at what are those benefits that are available to you and then utilize those. It's very important that you put this stuff into place. I wish I could come out there and talk to each one of you to help you understand why it's important for you to do this planning. Okay, moving on here to let's talk about a will. What a will covers. I put just a couple of things on this slide about what are guardians, funeral wishes, executor. Can you basically cover, Justin, for us, what essentially, what's in a will? What does it do? What are the kind of the key elements that people should be aware of?
A will is basically your plan for who gets what when you die, and whose job is it to carry out your wishes. If you have minor children, it's also going to say who you'd like to be the guardians of your kids. It's going to go over any funeral or cremation wishes that you have. It's basically your plan for death, who gets what and whose job is it to carry out those wishes.
So if you look at just a very basic will. So the thing that's going to come up is like, hey, I want on LegalZoom and I can do a will for $49.95. I don't know what they cost today, but
yeah.
And if I go to an attorney, it's going to cost me, tens of thousands of dollars. There's kind of a misconception out there. Tell us, what are some of the benefits of using a online fill in the blank sort of a thing versus going to an attorney? What are some of the pros and cons of each of those, and what kind of a range for just a basic will are we really looking at?
Yeah, so there are some good online do-it-yourself will services out there. Just know that with any of these, what you're buying is a template that is supposed to cover broadly everyone, and so it's not going to be getting into specifics. It's just going to state who are the heirs or the beneficiaries, who are the executors, and sometimes it doesn't capture your unique family situations or some of the assets that you have or specific details. It's just going to be very generic. And maybe for some people, that's all they want. They want everything to go to a surviving spouse and then the kids and equal shares. And that might work for someone that has a very standard kind of an estate plan. Those typically cost, I haven't been on LegalZoom in a while, but usually those are about $200 to $300 for do-it-yourself. For just a will, that doesn't include a trust or other things. Whereas the advantage of an attorney is they're going to learn your specific wishes, what you're looking to accomplish. They're going to know how to exactly write that in the document to address those concerns. They're going to include additional provisions in the will to help avoid disputes in the future. With that comes extra cost. I'd say a will drafted by an attorney is going to range anywhere from $400 to $1,000. So.
Okay, great. I hope that helps you out there understand really kind of the cost that you really are looking at for this, and maybe takes some of the mystery away from that. We just want to give you some options. So a couple of questions for you, Jordan. The first question is, we've talked about an executor. Can you just kind of define that in layman's terms? What is really an executor, so everybody knows who is that? What do they do? How do they get picked?
Yeah, an executor, their job is to make sure that your wishes in your will, or if there is no will, the wishes designed by the government, the state probate code, are followed. And so their first job is to make an inventory of all the assets, see what's there. Also make an inventory of any debts or liabilities that are out there, anything that's owed by the decedent. And then once they've done that, they need to make sure that those debts are paid with whatever assets are remaining. They're supposed to keep the heirs. Those are typically the children, whoever's going to be inheriting the property, or whoever's named in the will. They're going to keep them apprised of what's going on and provide them a report or an accounting of what's going on. After all the debts and expenses and all of that are paid, and if there's still assets remaining, then it's their job to divide them up, either how it says in the will or whatever the Utah code says. And then once they distribute everything, their job is done.
So could I term it as somewhat accurate to say you've assigned a referee to say, hey, here's my guidelines, here's the way I'd like things done. You handle this, and instead of handling it to maybe just the kids, the executor can do that.
Mm-hmm.
And in a lot of instances, the executor probably is one of the kids.
Exactly, yeah. Yeah, so the executor does have some discretion. Their job is to follow the wishes in a will, but there's going to be some decisions they have to make. Every little thing that someone owns isn't going to be listed in a will. All the furniture, clothing, equipment, tools, they're going to have to figure out still how to divide that up amongst the kids. If the home needs to be sold, they still need to figure out who's going to be the realtor, what's the sell price. So they are a referee. They are making a lot of decisions. So they have to be someone that you would like to have, or to be trustworthy and competent and willing to do that. Because although they have a plan they have to follow, they still have some discretion and they're still going to be making decisions.
So in kind of a perfect world, a good choice maybe for an executor, if I have, say, an oldest son or daughter, or one that is trained in a certain field, maybe that might help me pick if I want to have one of my kids be the executor.
Yes. Oftentimes adult children are the executors. If it is someone that is an accountant or an attorney or a financial advisor, someone that maybe is more familiar with administering an estate or managing one, they would be a good pick. You can name one person, you can name 2 or 3 people acting as co-executors. There's pros and cons to that. One person is great because it's simple and easy. You have one decision maker, but it is a lot. It is a burden to have to handle all of that while you're grieving the loss of a loved one. So sharing that burden with 2 or 3 people can also be helpful, and provided they get along, it could also invite more disputes if they're fighting. So
you bring up a really good point here about the fighting, right? And one of the things I would just advise is I would never pick 2 or 4. I'll pick an odd number, because you want to have somebody who can break a tie vote. And if you pick 2 kids, that's tough, because if they're at odds with each other, unless you put in your will that you want a coin flip. And I only use that because I used to set up corporate organizations, and that's what I would do to try to get people realistic, right? Because you've got to have some way to break the tie. So when we think about kids doing it versus having a quote professional executor, when would you recommend that you move away from maybe having one of the kids do it to having, maybe in the past it used to be a banker or a financial planner or your accountant or your attorney? When would you move away from the kids to a third party?
I think that's maybe not as common as it used to be, but I still have clients that need a professional executor or trustee of a trust. And in those situations, either they don't have children that are competent or old enough to act as an executor. Some of them might have drug or alcohol problems, and they need someone to kind of monitor that and make sure any inheritance is held in a trust or not given outright to children like that. Sometimes family dynamics are such that if picking one person might offend the others, or it might just be more fair or more neutral if they have a professional that makes all those decisions. That way it doesn't cause any conflict in the family. And then sometimes if it's a very complex estate, there's a lot of assets, then having a professional can help manage all of those assets better than just a child that may not know how to do that. So.
Well, let me ask you this: when we talk about conflict, how often do you see conflict in families? Even when they might have an estate plan, I mean, does that come out a lot? Is there a lot of that, or is it limited?
There's always some conflict, I would say, with every family. Even the closest families that I've seen, There's going to be some conflict. Usually it's over the little things in the home, who gets the piano, who gets the photo albums, who um, I've seen it ruin relationships that of otherwise close families, and it's again just little things. It's money. Um, it's very common. So the more uh, detailed a plan can be that kind of outlines who gets what and whose responsibilities are to do this or that, the better it can be to help avoid those disputes.
So if we have a will, we can put an addendum on there that basically is a listing, and ideally, it would list all the assets down to the thimble collection
Hmm.
that says, hey, we've talked about this, here's where it's going, and mom or dad have already decided that, and they've put names beside everything to make sure that we reduce the opportunities for conflict.
Ideally, that would be great if every item was listed out, but that never happens in my practice. I've never seen that. At at best, we will see the most expensive items or the most sentimental items listed out, um, but you're never going to have everything listed out. No one's going to go and do that. We do sometimes put systems in place for clients where there's maybe some auction system to help do that fairly, or maybe some lottery system or a snake draft system. There's different ways to help kind of facilitate those disputes for those little things. But yeah, there's always going to be something that's going to be left unsaid that we have to determine who gets that.
Right.
Yeah.
So let's say we don't have a will.
Hmm.
If mom has made a listing that she's, say, signed and dated and say,
Yeah.
here are my wishes, how is that used? Would that just be used by the probate court to give that weight? Or is there any way that
Yeah.
is that effective in any way, shape, or form?
There's something called a holographic will, which is a will that is written in the testator's own handwriting. So if they write it all in their own handwriting, that's actually valid. It doesn't have to be witnessed. It doesn't have to be notarized. The problem, I've seen some of those. The problem with those is it doesn't really spell anything out too clearly. It may just say, I want everything to go to the kids, or the house goes to this son. It doesn't name an executor typically. They don't think about that. It doesn't spell out the little wishes there, but that is valid if someone does write it all in their own handwriting. There is something called a personal property memorandum, which is for tangible personal property. If those items are in writing, it doesn't have to be handwritten, but if they're typed out and written down and then signed and dated, that is a valid way to dispose of personal property items, and that's legal and enforceable, even though it may not be a will. It's for tangible physical items in the home, that is effective as well.
Okay, well, great. Well, I hope that's helpful, right? We're trying to give you some tools and some things that you can do and to help move through this process more effectively. So let's talk a little bit about this with will limitations, and this will lead into where we're going, right? A will doesn't necessarily, it's not going to avoid probate. And we should be updating them routinely, right? Marriages, divorce. I mean, use one example for me. When I was younger, I have 5 children. And when we started out, I was closer in ages to my parents. And so in our will, we had parents would become guardians if we were to pass away. But as we got older, and I have now kids with kids, and my kids span 13 years, it became, you know what, it probably wouldn't be better for a parent. It might be better for one of the siblings.
Mm-hmm.
So this is one of the reasons why we want to revisit these things periodically to make sure that we've identified who receives children's, or if we've had a falling out. And one of the ways that we've gone about it is to really encourage our kids to think, who would raise your children as close to how you would raise them?
Mm-hmm.
And that's really how you're going to pick somebody and then have a conversation. How do you go about that with your clients to say, hey, here's how you're going to pick a potential guardian for your children, and what do you tell your clients they need to do with siblings to get that cleared?
Yeah, well, first of all, they should talk to whoever they want to be their guardians of their kids in that unfortunate situation. Make sure that they're on board with it. You don't want to name someone that is not willing to do it because they can't be forced to be a guardian. But typically what I've seen, our clients are going to choose for guardians. Usually it's siblings. Usually it's someone that's around the same age. Maybe if the parents are a little bit younger, not in their older years, then it might be parents first as guardians and then siblings. Um, but that decision is always going to go before a judge, whether you have a will or a trust or whatever. Who's going to be the guardian is always going to be up to a judge. A will is useful to help say what your wishes are, and the judge will lean heavily on what the will says on who should be the guardian. So having that in place is very important. But that does not avoid probate court. And so having an up-to-date will as your life changes, as the guardians change from your parents to your siblings to now you don't need guardians for your kids. Now maybe your kids are going to be the executors of the will. So over your lifetime, your will is going to change.
Okay, great. Let's talk now about trust. Can you explain the value of a trust and what is a living trust?
So this is probably the most common question I get almost every day. I get phone calls or emails asking, do I need a trust? What's the difference between a will or a trust? Do I need both? My simple answer is you need a trust if you own a home, if you own any real estate, or if you have young kids. And so the reason for that is the major trigger for probate court is real estate. If someone dies and they own a home, or land or any real estate, and that property is titled just in their name, there's no joint owners with rights of survivorship, then that property has to go through the probate court system in order to get the deceased person's name off of title so that we can sell it and transfer it. That's the number one trigger for probate court. If you have a trust, you can put your real estate into the trust so that the trust owns it. So that way, when someone passes away, their name isn't on title. We don't have to get their name off of title. It's in a trust. And whoever they name as what we call the trustee of the trust, that's basically the same thing as an executor, but just what we use for a trust. And they can sell the home, carry out the wishes, and that skips probate court.
So when we talk about this, and I know this can cause a lot of confusion, right? So for example, my home, I don't have the home in my name. It's in my wife's trust name, so that she has that ability to manage it. Now, it creates some complications when I go to get a second or when I go to refinance. I just have to provide the trust information to the mortgage company or to the bank to say, here's who owns this. But it's not a difficult process to go through. Can you kind of help everybody understand, kind of, because sometimes we're scared because we think, wait, it's not my name, to provide some comfort.
Yeah, so there's many types of trusts. The most common is a revocable living trust. That's what most people have. That's if they have a trust. That's the type of trust that people use just to avoid probate court. It's relatively simple. It doesn't overcomplicate things. If you have a living trust, you're going to be named the trustee of your own trust during your lifetime. So you still have full control of your home. You're still able to sell at any time. You can still refinance. The paperwork might look a little bit different when you sell the home, or if you refinance, you're going to be selling it as the trustee of your own trust. When you refinance, sometimes they want it back in your name, and then they do the close on the loan, and then they put it back in the trust for you. So there might be a little more paperwork, but really nothing's going to change. It might just be the way things are titled on deeds and things like that. A revocable living trust is very flexible. There's federal law that says that if you have a loan on your property, a mortgage, you are allowed to put your home into a living trust, and it doesn't enact the due on transfer clause. The lender has to allow you to do that. So it's really just nothing's going to change. It's just on paper, your trust owns the home. That way it stays out of probate court.
And all lenders are extremely familiar with this because a lot of people do it. So
Yeah.
It's not like this is unusual. The one thing that you brought up that I want to just point out is when we talk about a trustee being like an executor in a will, that you get to appoint yourself as a trustee. So when you're around, you are the trustee. You're not appointing a third party. You're not giving it away to any family member or to somebody else. Uh, you can be the trustee. So I could be the trustee of my wife's trust while it sits in there. She could be the alternate trustee or co-trustee with me so that we have the ability to make decisions and do what we need to do in that trust.
Yeah, and I think that's why they call it a living trust, is because it's effective during your lifetime. While you're alive, you are the trustee of your trust. You're managing, you're controlling trust property, whereas a will is only effective upon death. That's when it kicks in. That's when an executor starts to act. But a trust, a living trust, is effective during your lifetime, and you manage it.
So what else might we consider putting into a trust while we're alive for a living trust?
So real estate, we always put, for our clients, we always put all of their real estate in a trust. That's standard. That's the main thing. You can put any other asset into a trust. You can put bank accounts, savings, checking accounts, investment accounts. You can put vehicles into a trust. Now, having said all of that, at least in my opinion, a lot of those assets don't need to go in a trust. What you should do for financial accounts is make sure that you do have a payable on death beneficiary on file with the bank or with your financial advisor. When you have a trust, it's very easy just to name your trust as the death beneficiary. I found that accomplishes the same purpose of putting it in the trust, but it's a lot easier, less paperwork, less hassle than transferring all your accounts to a trust. As far as vehicles go,
Before you move on that trust, just so I make sure that everybody understands that. So when we talk about that trust, if I have a car, rather than changing title and have it be, this is going to be now owned by Ted's trust, I can basically designate that goes into trust, that's the beneficiary of my asset when I die.
Correct.
Okay.
Yeah. So like think of a life insurance policy has a death beneficiary, so that when someone dies, the beneficiary of that policy will receive the death benefits. Same thing with a 401k or an IRA. Those are tax-deferred investment accounts that cannot be put in a trust. They have to remain in an individual's name, but that's why they always have a death beneficiary. Whenever you create a 401k IRA, one of the things that you have to fill out is who is the beneficiary. When you have a trust, you can name your trust as the beneficiary of that 401k, of that IRA. That avoids probate court. That's pretty simple. So for financial accounts, what we typically advise our clients to do is name the trust as the beneficiary of those accounts. For vehicles, probate court is only triggered if someone has 5 or more vehicles in their name, and most people don't. And so rather than go to the DMV right now and update title to be their trust, update their car insurance to name the trust as the owner, most people aren't as concerned about that, and they'll just leave the vehicles in their own names because they have 4 or less. But that's where the will, and maybe we'll get into this in a moment, that's where you should have a pour over will that basically says anything I own when I die, like a vehicle that's still in my name, when I die, that should pour over to the trust. Everything is going to be considered part of the trust, and that will capture things like vehicles, your personal possessions, everything like that.
Okay, great. Now, I don't want this to feel like we're getting overly complicated. So what you just said is if we have a will and we have a trust, those are really just 2 things we need, and we can avoid a lot of this stuff we've been talking about because the will can say, I have a pour over trust, and those assets move over there, and we've got a trustee, which is again similar to an executor in the will. The trustee is going to have, and it could be the same person even, is going to manage that. So we're talking about 2 documents, no overcomplication. There's a whole bunch of crap that people can do, right? But you don't need to eliminate a lot of the issues and the problem, just those 2 things.
Yeah. An estate plan usually consists of 4 documents, and the 2 documents that plan for death are a trust and a will. That's half of your estate plan. That's planning for death. The other half is the power of attorney and the healthcare directive. And that's not planning for death. That's planning in the event of mental incapacity. Say someone has an accident, they're in a coma, they're going to need help with their finances, paying their bills, filing taxes. That's what a power of attorney is for, is who's going to be able to manage your money for you, make legal decisions for you if you're incapacitated in a coma, or most commonly it's later on in life, someone has dementia, they need their adult kids to help out, so they need a power of attorney to name their kids to manage their money for them. And then a healthcare directive is kind of the same thing, but for medical decisions. Who's going to make medical decisions for you? What are your wishes if you're on life support? That's the other half of an estate plan for incapacity.
So these 4 documents that we've got up on the screen really are the essential documents that if we have these, it's going to cover most of us for most of our needs.
Exactly. I would say everyone needs those 4 documents, with maybe the exception of a trust. If someone doesn't own real estate, they don't have younger kids, maybe they just need a will, power of attorney, healthcare directive. But those are the core documents. If you go to any law firm, that's what the attorneys would recommend to you.
And when we talk about a power of attorney, when we look at that in layman's terms, what is power of attorney? Because sometimes people can get confused. Wait a minute, I'm not an attorney.
Yeah.
What does power of attorney mean in layman's terms?
An attorney is essentially someone that can act for you. They have legal authority to act for you. So you're giving someone the power to act for you, to go into your bank and withdraw money. That's a power that you're giving to someone so that they can pay your bills. You're giving someone the power to sign a legal document, maybe your tax filing. It doesn't mean you are a licensed attorney. It just means that you've been given power to do certain things on behalf of another who's living.
Okay, that's a great clarification.
Yeah.
So all of you out there who never wanted to take the bar to become an attorney, guess what? You can be called a quote attorney if somebody gives you a power of attorney, because you get to sign their name on things. So very important to have that in place, particularly in the example of my elderly mother. If somebody has power of attorney there, then we're able to do some things in her name that she might not be able to do. So
one thing to add there that I think is a common misconception is that a power of attorney and a healthcare directive, they end at death. If someone dies and that power of attorney is void, that healthcare directive is void, I get people saying, well, I had power of attorney while my mom was alive. Now that she's dead, I want to be the executor. And that's not necessarily the case.
and you want that power of attorney because that allows you to go in. Hopefully what happens is as you have elderly parents, you might go on and get a co-signer on the account, which is probably better. But if you have that power of attorney, at least you can walk in with the power of attorney and hopefully add somebody to the account. Otherwise, mom's bank account gets tied up for way too long. Everybody's going, why are we not getting this money? And we ought to have access to our money to pay our funeral expenses. And yet you can't have access because mom died and nobody had power of attorney. Nobody was a co-signer on her account. And so very important to have that power of attorney in place. Healthcare directive. This is dictated largely by the state. Tell us what's in a healthcare directive and what's really in there. What decisions are being made in a healthcare directive?
Yes, a healthcare directive is written by the state. It's basically a form. You can find that form online for free. If you just Google a Utah healthcare directive, just know that it's a form out there. You don't need an attorney for that one, although sometimes it is helpful to walk through it. But basically, it includes 2 parts. The first part is a medical power of attorney. That's where you designate someone to be your agent, your attorney for medical decisions, so that if you can't make those yourself, they can make decisions such as what medications you're on, what doctors you see, what surgeries will be performed on you. So that's the first part of a healthcare directive. The second part is what they sometimes call a living will, and this is your life support wishes. So if you're in a coma, hooked up to life support, what are your wishes there? They have 4 options on this form. You can pick someone to make that decision for you, usually your spouse or children. You can say, keep me on life support as long as possible, although I rarely see anyone pick that one. Option 3 is we're just going to let the doctors make that decision based on certain criteria, and you could choose the situations under which the doctors would pull the plug, such as if you're in a coma and you're not going to recover, you can't communicate, you're not going to recover. You don't recognize your friends or family. So you can spell it out for the doctors and they'll make that decision so that your family doesn't have to make that. For some people, that might be too much of a burden. And then the fourth option is just you have no preference. So those are the things in a healthcare directive.
All right, and this is really important to understand. And if you've been with us and you've heard us talk about the reservoir of resilience and some of the stuff that we provide when we talk about, are you in a place of regulation or the green zone, or have you moved to fight or flight, or have you moved to freeze? If you are in the situation where you're in the hospital and mom is dying, or somebody else is dying in your family, you are not always in a place of regulation. And in fact, it's pretty difficult to stay in a place of regulation. You're not really in a great state of mind to make a solid, a rational decision. So it's best if you can have these healthcare directives and living will in place before that situation arises. Now, you still might, in a state of fight or flight or freeze, you still might say, "Wait, I didn't mean that," all these sorts of things. But if I have a healthcare directive and my kids know that I have said, look, I do not want to be in life support, and I don't want to prolong my life after this point, that is something that, again, now your kids who might go into, or you for a parent might go into, again, a dysregulated state where you're not thinking clearly. That's already been decided by the person that you're there for and helping. So really key that you have this. And what Justin said is very important, right? You can go online and download this because it's a statutory prescribed form that they have. So that's something you can do on your own. A power of attorney is something that you can easily do on your own to have something. Now, obviously, we always recommend you go and find an attorney that's a fit to put this stuff into place. But these are things that you can do on your own. So just be aware of that. All right, as we look at this, we've talked a lot about some of the issues around this, and let's kind of get into getting started, because I know we've tried to keep this even a little bit simple here, but it still can feel and seem overwhelming when you're not familiar with these terms, when you're not familiar with the processes. And I've just listed a couple of things up here to say, how do you get started? But beyond this, if I said, Justin, look, I don't have a lot of money. I just want to put a few things into place. And I know this will reiterate some of the stuff we've already talked about. Where do I start? What should I start with?
Well, I think just at a base level, kind of as it says there on the screen, just formulate in your mind, what are your wishes? Who's going to inherit your property when you pass away? Who's going to raise your children? Who's going to make decisions for me if I can't make them? Who do I want to be responsible to carry out all of these wishes? You don't need to know legal terms. You don't need to know what a trust is or what an executor is or a trustee. Just basically just formulate in your mind what do I want to happen. From there, if I would say the next step is, if you're comfortable doing it yourself and your plan is fairly basic and vanilla and straightforward, maybe look at do it yourself options. Like I said, I've looked at some of those. Some of those are really good. If your plan is very straightforward, if you have anything that kind of strays from the very typical, then I would recommend a free consultation with an attorney. Most estate planning attorneys give a free consultation. I know we do that at our firm. And in that consultation, I just listen to the clients, figure out what are their wishes, what they want, and then I know how to craft their documents and draft them to accomplish their goals. And then, as I said before, process can be pretty simple. We have that initial consultation. We get an idea of what they want. A few days later, I have their documents drafted. I email them to them so they can look them over, get back to me with questions, further customization they want. Once they're happy with them, they just come and get them signed. And it's as simple as that. So it really can take about a week or less even if it really needs to be done quickly. So.
Okay, well that's awesome, and one of the things that's important to know too, is make sure that you if you want to get an attorney involved with you, what Justin just said is most of them, and in this arena, I would encourage you to go somebody who gives an initial free consultation. because they're going to know what your needs are and they can kind of define where you need to go and what you need to do. But find an attorney that's a fit for you as well, because you want to revisit. You want an attorney that's good at communicating, that gets back in touch, and every so often is going to say, "Hey, it's probably time to look at your estate planning documents again to make some updates." Get somebody who's a fit. All right. Obviously, Justin's a great friend. I love Justin. If you want to talk to him, we'll put his email back up. You can contact him. There's great, like I said, great resources at the county that are going to be made available, and they might have some people that they have for you to talk to as well. So just find a nice fit for you. It's important to shop for attorneys because you are working with them and you have the ability to shop. You don't have to go with the first person who walks in the door. And do some due diligence, make sure that you're comfortable with them. That would be smart. Now, I'm going to just quickly just bring this up. If some of you were on the presentation yesterday, we talked about finance. We are doing for the county and for others who would like to a 90-day financial resilience challenge. And this is basically gets into creating your 90-day in 90 days, creating an emergency fund. And we've targeted $1,000 for most people, which is a good target to kind of have. If you're interested in that, go ahead and scan this, sign up. It's free for you to participate in. It is a 90-day challenge. We're dropping lessons each week or things that you can look at, and you'll be able to use the Saveology tool, which is a tool that's available. We've also put in if you want to see yesterday's presentation on finance, there's a link on there. You can go on and you can take a look at that, where we had Brian Case from Saveology come in and answer some basic questions about Finance 101 and understanding finance. Feel free to join there. And then if you are with a client of Vest, you please download the app. You can download the app to get access to Vest, to Saveology. And then I've put Justin's email up there. If you want to reach out to him, you're more than welcome to reach out to him as well. So at this point, I know we've covered a lot of ground. We haven't really had questions come in. If you do have any questions and you want some clarity, we've got just a couple of minutes. We'll close out here in just a couple of minutes. But is there any questions? Sadie Mae, is there anything else you wanted us to cover or anything that comes up for you here as we finish up?
I just wanted to say thank you so much. You provided above and beyond what we even expected. So I really appreciate it.
Well, thank you so much. And I know you've recorded this and we'll have a recording of it. So if anybody wants it, or if anybody on the call, if you want to provide it to somebody, a loved one, family member, to anybody else, coworker, it'll be available for you to use and view again as well. And the nice thing is you can skip to the part that that you have some interest in or that you need a little bit more information in. You're welcome to email me. I'm Ted at Lexicon, is where you can get in touch with me, and or Ted at vesteap.com. Either one of those. I'm happy to answer questions. My team is happy to answer questions. Again, Justin is happy to answer questions. Justin, I'm going to give you the last word here. And thank you again for coming in and participating with us. Any last pearl that you would throw out there to help encourage people to take that first step?
I would just say it's not as difficult or overwhelming as it may seem to get your estate plan done. And also there is a lot of peace of mind in getting it completed. I actually put this off for about 1.5 years. From the time I was doing this for other people, I was an attorney, and my wife kept bugging me to do our own estate plan. And it was just one of those things, oh, we're young, we're not going to die anytime soon. And so I put it off myself. I think everyone I speak to has put it off. But once you get it done, I found just for myself, I had some peace of mind. I have younger kids. There's a plan in place for them. Who's going to raise them? How is money going to be managed for them? For 1.5 years, I was worrying about it, thinking I need to get it done. As soon as I got it done, there's peace of mind. You don't have to worry about it anymore. So it's really not that bad, and it gives a lot of peace of mind. So that's all I'd say on that.
Okay, awesome. Again, thank you, Sadie Mae, for having us. Salt Lake County, thank you for allowing us to do this. And Justin, thanks for coming into studio. And Mike, behind the camera, thanks for all your work with us as well. Appreciate you joining us. and look forward to having another conversation sometime. All the best.